Good afternoon, ladies and gentlemen. The Government Operations Committee will come to order for March 14th, 2022. Madam Clerk, please call the roll.
Representatives Byrd, Calfee, Camper, Cochran, Dixie, Faison, Johnson, Lafferty, Lamberth, Littleton, Marsh, Stewart, Warner, Vice Chairman Reedy, Chairman Reagan.
Here.
Mr. Chairman, you have a quorum.
Thank you, Madam Clerk. Members, I'm going to call for personal orders. Does anybody have any? The chair will exercise privilege in that case. The chair would like to recognize Ms. Robin Randall, who is visiting with us, the mother of our intern. Would you please stand? Thank you very much. One other personal item to be announced. Chairman Byrd, whose name was called, is currently hospitalized. So if you could, please remember him in your thoughts and prayers. Any other personal orders? You're recognized, Chairman Warner.
Thank you, Mr. Chairman. Yeah, I'd like to recognize former State Senator Jim Tracy.
Representative Johnson, you're recognized.
Thank you. I'd like to recognize a teacher from back home at Central High School, teacher and coach Larry Williams.
Chairman Faison, you're recognized.
Thank you, Mr. Chair. Ladies and gentlemen, if you look on the front row here beside David Hawk is a beautiful young lady named Kaylin. When she was born, I actually held her on the house floor 10 years ago. I reckon, is it about 10 years ago, David? Yeah. But anyway, she's on spring break this week. And I didn't know if, since Mr. Representative Hawk is not on the committee, I just wanted y'all to see this beautiful little girl that he had something to do. We're still wondering how that happened, but welcome, young lady.
Thank you. Any other personal orders? Seeing none, we will take care of some housekeeping first on our calendar.
Hey.
Item number 9, House Bill 2615 is off notice. Next on the agenda is item number 1, House Bill 2661.
Motion.
We have a motion
Second.
and a second. We have a motion and a second. Being carried by Chairman Spicki. Chairman Spicki, you have a motion and a second. Before we recognize you for explanation, your bill is traveling with an amendment. Is that correct?
That is correct, Mr. Chairman. It should be 014713.
That's what we show. Nothing to be added in this committee on that. You are cleared to explain your bill, sir.
Thank you, Mr. Chairman and members. Good afternoon, everybody. Last year, we passed historic PBM reform legislation, and one of the intents of that legislation was for pharmacies to be reimbursed no less than the actual cost of a drug or device dispensed to a person. During the summer, it came to our attention that due to a definition issue, that intent wasn't realized in the legislation. This bill today fixes that definition and assures that the pharmacies or pharmacists will be reimbursed no less than actual cost. While working on this bill this summer, we did find multiple loopholes in the law that would have allowed PBMs to circumvent the intent of last year's legislation. This bill will also close those loopholes, like stopping PBMs from reducing a dispensing fee to offset reimbursing at actual cost for a drug or device, or a PBM from charging a pharmacy an additional amount to process a claim. This bill requires a PBM to have a reasonable appeal procedure for any pharmacy to challenge a reimbursement amount if it is less than what the pharmacy paid to acquire the drug or device, allows the Department of Commerce and Insurance to promulgate rules to allow for an external appeals process for any claim denied by a PBM, requires all PBMs to pay a pharmacy a dispensing fee at a rate not less than the amount paid by our TennCare programs, and requires that all PBMs allow participants of the PBM plan to use any pharmacy within the state that is licensed to dispense the drug or device, as long as the pharmacy agrees to accept the same terms and conditions that the PBM has established for at least one of its networks. With that, Mr. Chairman and committee, I renew my motion.
Members, you've heard an explanation of the bill. Do we have questions of the sponsor? You're recognized, Leader Dixie.
Thank you, Mr. Chairman. Does this bill require the pharmacist to let the patient or consumer know the cash price or the pharmacy or the deductible for a particular prescription?
You recognize sponsor?
I believe that this bill does not address that at all, Chairman Dixie.
Thank,
Do we have other questions of our bill sponsor? Seeing none, we are voting on sending House Bill 2661 to Finance, Ways and Means. All in favor signify by saying aye. Aye. All opposed, nay. Ayes have it. Bill moves out to Finance, Ways and Means.
Thank you, Chairman and Committee.
Next on the agenda, House Bill 2667 by Speaker Sexton being carried by Chairman Vaughn. We have a motion and a second, Chairman Vaughn. And is your bill traveling with an amendment? I believe it is.
Yes, sir. Mr. Chairman, the amendment makes the bill. It's 015223.
The amendment is on the bill. This committee does not need to act on that. So since you have a motion and a second, sir, would you like to explain your bill?
I would, sir. We all realize that the hospitals throughout the state have going through staffing emergencies. It first became evident during the COVID issue. What this bill will allow the Commissioner of Health to do is to not declare a state of emergency, but to declare a healthcare staffing emergency. This is recognized by the Commissioner of Health, and she reports it to the governor as well as the Speaker of both houses. What that'll do is that will allow hospitals to implement some of the other tools that were in our toolbox during COVID to allow them to deal with short-term staffing problems in a hospital. And I can go into those in detail if you'd like, sir, but I stand by to take any questions.
Members, you've heard an explanation of the bill. Representative Stewart, you're recognized.
Am I remembering correctly? What that does, it allows for moving people in more quickly to take over particular positions in hospitals in terms of credentialing and that sort of thing. So what you're doing is essentially giving the commissioner the right to issue this directive less than a state of emergency.
Sponsor?
That is correct. It would be a state of emergency that strictly deals with hospital staffing, but you're right. One of the tools that they use is they allow for reciprocation from other, in between licensing from other states, people coming in, and that way they can get on the floor more easily. Also has to do with some nursing credentialing that allows them to work under RNs, be helpful on the floor in between testing and licensing.
Thank you.
Any follow-up? Okay. Any other questions of our sponsor? The question has been called. Any objection to the question? If not, we are voting on sending House Bill 2667 to Calendar and Rules. All in favor indicate by saying aye. Aye. All opposed by nay. Ayes have it. Bill moves out to Calendar and Rules.
Thank you, sir.
Next on our agenda is House Bill 2468 by Chairman Baum. We have a motion. We have a motion and a second. Thank you. Chairman Baum, you have a motion and a second on your bill. I believe it is traveling with an amendment. Is that correct, sir?
Yes,
I show drafting code 14266. Is that correct?
correct.
And it's already on the bill. No action required in this committee on that. You're cleared to explain your bill, sir.
Okay, thank you, Chairman Reagan. This is a bill that makes several changes and clarifications to the part of our code that governs charter schools. Some of these are relatively minor. I'd like to go through them. The first one says that if a charter school applicant does not have plans to provide transportation services, then they don't have to provide a transportation plan in their application. A second change says that if a charter school organizer or administrator runs other charter schools in an LEA, then when it applies for an additional charter school, those other charter schools must be reviewed by the LEA when it's evaluating the application for the additional charter school. A third change says that if the LEA changes the grade bands that are directed to each school, elementary school, middle school, and high school, that the charter school be notified at least 120 days prior to implementation of that change in the grade bands. It is my understanding that Knox County, Hamilton County, Metro Nashville, and Shelby County currently allow students from outside of the LEA to attend schools inside of the LEA. This bill would cap the number of students that could attend a charter school from outside of an LEA at 25% of the student body. This also provides some additional details on what the charter school could do if it is oversubscribed. If more students want to attend the charter school than there are seats, then the charter school has to implement a lottery approved by state government in order to decide who gets those seats. This bill would allow the charter school to provide additional weight in that lottery to certain kinds of students, which include at-risk students, economically disadvantaged students, and homeless students. And then there's one more change that I'd like to highlight. If the charter school is somehow out of compliance, this bill says that the authorizer would be required to give the charter school an intervention policy or plan to give the charter school an opportunity to get into compliance before revoking its charter, unless certain conditions apply. If the charter school is suspected of fraud or some kind of violation of health and safety standards that would endanger students, then this intervention policy is not required. I'd be happy to answer any questions.
Members, you've heard an explanation. I saw Representative Johnson's hands first. Representative Johnson, you're recognized.
Okay, thank you, Mr. Chairman. So, wow. I got a lot of concerns here. I'll try to keep it all into one question for you. So currently we have about 112 charter schools in the state of Tennessee. Only 5 of them are performing better than 20% success. We've got 38% that perform below 5% success. 77% charter schools form below 10% success. And it sounds like you're wanting to give them a way to stay open, even though for years the performance has been low. I see where you're allowing folks that are on the board or staff of charter schools to attend charter schools. It looks like everything we're doing here, allowing kids in from other counties and allowing more of certain kids in, is to get those scores up, because charter schools aren't able to do it right now. Charter schools have not been successful. They are not an answer. And this sounds like it's doing everything it can to give them a few bumps and also to stop them from being closed down like other schools that already have to go through a process of corrective action. And you're allowing these folks another way out when they have demonstrated year after year they are in the bottom of the barrel.
Representative Johnson.
Are you not afraid of what's going to happen if we proliferate these charter schools like folks are talking about?
Mr. Sponsor, you're recognized.
Representative Johnson, I don't think you're quite correct about that. For example, this bill would allow charter schools to give additional weight in lotteries to students who are at risk, homeless, or economically disadvantaged. Probably that's not a recipe for pulling up test scores.
One follow-up, please.
And that's just going to increase the amount of funding that those folks are pulling away from our traditional public schools. Charter schools are not an answer. They haven't proven. We saw with the ASD that we should have shut it down, and we're allowing it to go on in some form or fashion. But this is not a solution. You're continually putting our traditional kids at risk and not addressing the fact that our traditional schools are underfunded, and you are continuing to underfund them more with legislation like this.
Mr. Sponsor, comment?
There's a broader debate about charter schools, and I understand that. This bill doesn't seek to resolve that debate. It just seeks to clarify particular elements of the code. And some of these clarifications and changes, I would argue, make things stricter on charter schools. For example, if a charter school organizer has other charter schools in an LEA, then when it comes forward with an application for a new charter school, the LEA must review the performance of the other charter schools run by this administrator. This puts in code the requirement that occur. That would be one example of how the bill would make things more strict. Allowing charter schools to enroll with greater weight in lotteries, disadvantaged students is something that I don't think a charter school would do if they're trying to pull up their test scores. It's a way to allow them to provide broader services across the community for students who may have unique and special needs.
Representative Johnson, I'll come back to you. There's people on the list before you. Representative Stewart, you're recognized.
Thank you, Mr. Chairman. I've got a technical question. Right, this bill, as you've got it, you said you put a cap on enrollment of out-of-county or out-of-district kids. But what you also do is you're entirely removing the local control, right? Right now, if a county in this state, other than the ones you mentioned that have made their own choice, say Anderson County outside of Knoxville, Cocke County, if those, right now, those counties have total control through their out-of-district policy to decide whether they take kids from out of the district, and they can not take any. And you're eliminating that local control with your bill, right?
Mr. Sponsor.
I think you're partially correct. My understanding is that right now, the 4 counties that have charter schools allow those charter schools to enroll students from outside of the LEA. And again, those that I'm referring to are Knox County, Hamilton County, Metro Nashville, and Shelby. This bill would permit that to continue, but with a cap. And so from that standpoint, the cap would make things more stringent on charter schools because they couldn't enroll more than 25% of their student body from outside of the LEA. However, I do think you're correct that there are other counties in the state, there are other LEAs in the state that don't currently have charter schools, but this provision would apply to them as well, which again would mean they could enroll students from outside the LEA, but not above the 25% cap.
Representative Stewart, follow up, please. One.
Yeah, but that's not exactly accurate, right? It's not you're saying they could enroll. Right now, let's take just a random county, Cocke County. Cocke County right now has 100%, and all the counties in the state, their LEAs have 100% control over whether or not they accept out-of-district students. And your bill, I think the primary purpose, but certainly the most significant purpose of this bill is to eliminate that control by the school boards, so the charters will have plenary authority to accept those students, and the school boards will have absolutely nothing to say about it. You're putting a cap on, but that's a little bit, isn't it, like putting a cap? If I say today, I'm going to put a $25,000 cap on bank robbery. If you rob 26,000, you're going to jail. I just made robbing 25,000 legal, okay? Right now, it's illegal for any charter school to accept a student from out of county unless that school board votes to accept it, and you're eliminating that school board's power. Isn't that what this bill does?
Mr. Sponsor, you're recognized.
I think you're partially correct in that this clarifies in state code that students from outside of an LEA can attend the charter school with this cap of 25%. My understanding is that the 4 counties in the state that currently have charter schools already have such a policy, but without the cap. So the two changes being made are, this is clarifying in state code that this is permissible. It's also adding a cap.
Leader Dixie, you're recognized.
Thank you. Thank you, Mr. Chairman. I have a quick question. I was reading your bill, and it goes back to the, excuse me, when we were talking about earlier, is the closure or the termination of a charter school. It says the unencumbered public funds from the public charter school automatically revert back to the authorizer. Now, what if it was the charter school commission that authorized it? Where would those funds go?
Mr. Sponsor.
My understanding is that this bill makes no changes to the part of the code that would affect what happens if a charter school has debt and closes. Now, there is a part of that section of the code that was altered. The part that was altered was to give the charter school 120 days notice when the grades that are distributed to elementary, middle, and high schools are changed. The charter school finds out about that within 120 days. That part of this section of the code changed, and so the whole section of that code was reprinted in some of the documents you may have. But my understanding is that this bill makes no changes to the procedure that occurs in the event that the charter school has debt or outstanding liabilities.
I guess that's my question. I'm sorry.
Follow up.
I'm sorry. I guess that's my question. So what is the procedure? Because right here, it clearly says that it reverts back to the authorizer. So I'm assuming I need to know which authorizers these funds are going to or where they're coming from. So who's going to actually receive them? And it kind of goes back to my earlier question that I had, last week is that, and that this bill doesn't address this, but I think it may be something worth looking at, and making sure that charter schools have a surety bond so to protect the taxpayers' interest, so that that debt doesn't fall back on taxpayers and our local school systems.
Leader Dixie, Chair will exercise privilege here. Having done research on your question earlier, there are other provisions in the law that take care of your question. This bill does not change those provisions. Mr.
Okay.
Sponsor, do you wish to add anything?
I think just to reiterate that, this bill doesn't change those procedures. You're asking about what happens to these funds, and you're correct. The code as currently written says that unencumbered public funds from the charter school automatically revert back to the authorizer. I don't have additional information about that for you. This bill doesn't change that, but I am aware that that section of the code was reprinted when the 120-day notification period was added to that section.
Chairman Warner, you're recognized.
Question on the bill.
The question's been called. Do we have objection? I see 3 hands. We are voting, or do you wish to withdraw your? We're voting on whether or not to sustain the objection. In other words, continue debate. All in favor of calling the question indicate by saying aye. Aye. All opposed, nay? No. Ayes have it. The question has been called. We are voting on sending House Bill 2468 to Finance, Ways, and Means. All in favor indicate by saying aye. Aye. All opposed, nay? No. Madam Clerk, please take the roll.
Representative Byrd. Calfee. No. Calfee, no. Camper. Cochran. Aye. Cochran, aye. Dixie. No. Dixie, no. Faison. Faison, aye. Johnson. No. Johnson, no. Lafferty. Aye. Lafferty, aye. Lamberth. Littleton. Lamberth, aye. Littleton. Aye. Littleton, aye. Marsh. Stewart.
No.
Stewart, no. Warner. Warner, aye. Vice Chairman Reedy. Aye. Reedy, aye. Chairman Reagan.
We stand by. Question has arisen here. Did you call Leader Camper's name, Madam Clerk? Representative Harris is sitting in for her. Did you call his name? Okay. Reagan votes aye.
3. Reagan. Reagan, aye. Right. 1, 2, 3, 4, 5, 6, 7, 8. 8 ayes, 5 noes. Call for Marsh. Okay. Okay, aye. 9 ayes, 5 noes.
The bill moves out to calendar and rules. I'm sorry, Finance, Ways, and Means. Thank you. Next on the agenda is House Bill 2308 by Chairman Hawk. We have a motion.
Thank you, Mr. Chairman. I appreciate Chairman Faison recognizing my daughter. Thank you very much.
Chairman Faison was your second, by the way. Sorry.
Thank you. House Bill 2308 actually takes a bill we passed last year and moves it in another direction, or furthers the bill. Last year we passed legislation that said you cannot share publicly photographic evidence of a minor killed in an automobile accident. This bill actually translates it and says you cannot share photographic evidence of a minor in any accidental death. And that's what the bill does, Chairman and members.
Members, you've heard the sponsor's explanation. Do we have any questions of the sponsor? The question has been called. Any objection? Seeing none, we are voting on sending House Bill 2308 to calendar and rules. All in favor indicate by saying aye. All opposed, nay. Ayes have it. Bill moves out to calendar and rules. Thank you, Mr.
Chairman and
Sponsor.
members. Thank you.
Next on the agenda is House Bill 677 by Hall. Mr. Chairman Hall, you recognized? We have a motion and a second. Chairman Hall, I see your bill is not showing any amendments. Is that correct?
That is
I
correct.
see one amendment. I'm sorry.
There is one amendment, drafting code 1378-1, Mr. Chairman.
That is traveling with it, so we don't need to take action on it in this committee. That being said, Mr. Sponsor, you're clear to explain your bill as amended.
Thank you, Mr. Chairman. In committee, House Bill 677 potentially could benefit Tennesseans' lives better than any bill drafted on the Hill this year. Historically, if a patient is diagnosed with a disease, the patient would have to go through a regimen of substandard and ineffective drugs. It's called first to fail. House Bill 677 changes all of that. It puts the patient in the best chance of success, and it eliminates all of the substandard and ineffective drugs. And it also creates cost avoidance and also aggressively attacks the disease before it travels 6 months or a year down the road. And with that, Mr. Chairman, I renew my motion.
Committee members, you have heard the explanation of the bill. Do we have questions of the sponsor? You're recognized, sir. Chairman Stewart, Representative Stewart.
Yeah, is TMA taking a position on this bill? The doctors, they'll be prescribing these drugs.
Mr. Sponsor, you have a question? You're recognized.
Thank you, Mr. Chairman. The first rule of medicine is to do no harm, and delayed treatment is harm. This puts the patient in the best chance of success and aggressively treats and diagnoses the patient.
Pardon me, Representative Stewart, you're recognized.
Yeah, my question's just more simple. Has TMA taken a position? Have you talked to the doctors, and have they taken a position on this bill one way or the other?
Just a second. Chairman Stewart, for those watching online, would you explain your acronym TMA?
Oh, Tennessee Medical Association.
Thank you. Mr. Sponsor, you're
And I'd be
recognized.
interested in any other similar associations, hospitals, what have you.
You're recognized, sir.
Thank you, Mr. Chairman. Representative, it's my belief they haven't taken a position on this bill.
You have a follow-up, sir?
No, thank you.
Do we have other questions of our sponsor? Seeing none, we are voting on sending House Bill 677 to Finance, Ways, and Means. All in favor indicate by saying aye. All opposed, nay. Ayes have it. Bill moves out. Finance, Ways, and Means. Mr. Representative, you are also item number 6 on our calendar. House Bill 874. Do I have a motion? 847. I'm sorry, 847. Thank you. Motion. We have a motion and a second. And I show your bill is traveling with an amendment, sir, drafting code 13346. Is that correct?
That is correct, sir.
Already on the bill, no action required in this committee. Sir, you are recognized to explain your bill.
Thank you, Mr. Chairman. House Bill 847 is very simple by design. It makes Tennessee more attractive and competitive in recruiting and retaining special education teachers. This is a scholarship which pays $750 a semester, and upon graduation, the educator agrees to a 3-year commitment in teaching special education. And with that, Mr. Chairman, I renew my motion.
Members, you have heard an explanation of the bill. Do we have questions of the sponsor? Representative Johnson, you're recognized.
Thank you, Mr. Chairman. Just a thank you. I appreciate this, and it's a good bill.
Other questions, comments for this? You're recognized, Chairman Lafferty.
Thank you, Mr. Chairman. Sponsor, with the $750 a semester, is that going to be, say the person graduates, doesn't proceed down the path that they agreed to, goes off in a different direction, are they going to have to pay that money back?
You're recognized, Mr. Sponsor.
Thank you, Mr. Chairman. That is correct, sir. It's a contractual agreement with the educator in the state, and if they choose not to pursue it, then they are required to pay the money back that they received from the great state of Tennessee.
Follow up, sir.
And that amount of payback is just the $750 for this additional scholarship, or does that include any underlying fees that were taken care of by the taxpayers?
Mr. Sponsor.
It's the $750 that they received from the scholarship fund.
Oh, thank you.
Thank you.
Do we have other questions of our sponsor? Seeing none, we are voting on sending House Bill 847 to Finance, Ways and Means. All in favor indicate by saying aye. All opposed, nay. Ayes have it. Bill moves out to Finance, Ways and Means. Thank you, Mr.
Chairman.
Sponsor.
Committee.
Next on our agenda is House Bill 2153 by Chairman Haston. We have a motion and a second, sir.
Thank you, Mr. Chairman. Glad to carry this bill for the administration.
I show your bill is carrying an amendment. Is that correct, sir? Drafting code
Yes.
14160?
That's what I have.
And it's already on the bill. This committee needs to take no action on that amendment. You are recognized to explain your bill, sir.
Thank you, Mr. Chairman. This computer science bill helps to make sure our students are better prepared for the technology jobs today. Does so in three key ways. First, it sets rigorous standards for computer science education. Second, it requires instruction and course offerings in computer science for all Tennessee students. And third, it will provide free professional development for Tennessee educators. And with that, I'll be glad to answer any questions if there are.
Members, you've heard the sponsor explain his bill. Do we have questions of the sponsor? Representative Johnson, you're recognized.
Thank you, Mr. Chairman. So after talking to the department, I put a shout out to all teachers to ask them, how they felt about it. And we do have a lot of teachers asking for half a year instead of a whole year. They're concerned about some of the losses there. And, but that was the only big complaint I heard. And then maybe finding some other substitution besides just the fourth year math.
You recognize, Mr. Sponsor?
Thank you. Right now the fourth year math is already in code and in place. I will say that I think that there have been in talks about possibly going to one of the sciences as well. I think that was something that we will be able to get across the line pretty soon.
Any follow-up? Any additional questions? Seeing none, members, we are voting on sending House Bill 2153 to Finance, Ways and Means. All in favor indicate by saying aye. All opposed, nay. Ayes have it. Bill moves out to Finance, Ways and Means.
Thank you, Chairman and members.
Next on our agenda is House Bill 2146 by Speaker Marsh. You have a motion and a second, Speaker Marsh, and I show your bill traveling with an amendment. I have drafting code 14154. Is that correct, sir?
That's correct.
It is already on the bill. No action required in this committee. You are cleared to explain your bill, sir.
Thank you, Mr. Chairman. This bill comes to us from the governor's office with the blessing and help of Department of Safety and Commissioner Long, Elizabeth Stroker, and her whole department. We've all worked on this for quite a long time. And what this bill concerns, it will deregulate the process of obtaining a commercial driver's license, removing barriers while ensuring the safety of all Tennessee drivers, will help increase the number of commercial drivers, which in turn will help address the shortage of truck drivers and reduce the problem involving supply chain shortage. What's going on currently is the department has got several positions that are not filled because primarily they don't pay enough. And now if you want to become a truck driver, you have to take a written commercial driver's license test. If you pass that, then you have to make an appointment to our driver's testing center, which closest one to Shelbyville is Columbia, which is about 50 miles away. Once you pass your written test, you try to make an appointment. It's anywhere from 6 weeks to 3 months before you can get on the list to go take a test. And when you go to Columbia to take the test, you have to take your own tractor and trailer. So therefore, you have to hire your own driver who has a license to take you there. It's a very hard, long, drawn-out process. And we found out that these guys and ladies, if they're trying to become a truck driver, they don't have this time to wait. They need a paycheck. So what we've worked out with Commissioner Long and Elizabeth and the Department of Safety is to allow third-party testers to come on site in Tennessee. We used to have this several years ago, and it didn't work out right. So what we're going to try this time is to bring on several third-party testing companies and give the department some extra funds to hire auditors to go out and audit these third-party testers. Therefore, we should be able to bring a lot more drivers online. The department tells us that they have over 3,000 potential drivers waiting in line to get this test. So I think this is very sorely needed. This allows third-party skills testers They're going to hire more auditors. It also allows 18-year-olds, which are now not allowed to drive as CDL drivers. It allows 18-year-olds to drive within the state of Tennessee. So this is we finally get a chance to capture some of the high school graduates to be truck drivers and teach them locally how to drive before they become long-haul drivers. It also allows our TCATs, Department of Correction, Department of Labor, Military and Veteran Services to get involved in teaching a lot of their guys to be truck drivers. With that, I'll answer any questions.
Members, you've heard an explanation of the bill. Do we have questions of our sponsor? I'm sorry. Chairman Dixie, you recognized.
Hey, thank you, Speaker Morris. I had a quick question. Once the 18-year-old becomes 21, do they have to take a test again, or do they just get an updated license?
Mr. Sponsor, you recognize.
The way I understand it, they would just get an update in their license where they can travel outside the state.
Follow up.
Thank you.
Any further questions of our sponsor? Seeing none, we are voting on sending House Bill 2146 to Finance, Ways and Means. All in favor indicate by saying aye. All opposed, nay. Ayes have it. Bill moves out to Finance, Ways and Means.
Thank you,
And
Mr. Chairman, member.
Item number 9 has been taken off notice. That takes us to item number 10. I pass the gavel to Vice Chairman Reedy.
Thank you, Mr. Chairman. Members, item number 10, House Bill 1814. Can I get a motion and a second?
Motion.
Got a motion and a second. Chairman Reagan, you are recognized, sir.
Thank you, Mr. Chair. This bill extends the TWRA to 2026. With that, I stand ready to answer questions.
Thank you for that. Any questions from the members? Seeing, before we go there, I would like to say thank you to our commissioners with TWRA. They do a great job for the state of Tennessee. The question has been called. All in favor of moving them out to calendar and rules signify by saying aye. Opposition, nay. And of course, the commissioners are coming in now. Gentlemen, we appreciate you, and that we exercise that bill just that quick.
Mr. Chair, could the sponsor exercise
Yes, sir.
privilege?
Chairman Reagan, please.
The sponsor would like to say thank you to all of the commissioners that are here, and congratulations on a job well done. We will no doubt see you in this committee again before too long. So thank you. Thank you, Mr. Chair.
Thank you, Chairman Reagan. And members, the last item, number 11 on the calendar, House Bill 1748. Can I get a motion?
Motion.
We got a motion and a second on the bill. Chairman Reagan, I see that there is an amendment that makes the bill. Would you like to move forward with that amendment?
Thank you, Mr. Chair. I have a drafting code 15478. I move to put the amendment on the bill, sir.
That is correct. Can I get a motion and a second? And we've got the motion and a second. All in favor of putting amendment number 15478 onto House Bill 1748, signify by saying aye. Any opposition, nay. Amendment goes on. Chairman Reagan, you are recognized on House Bill 1748, sir.
Thank you, Mr. Chair. Committee members, this is the first of 2 bills of great import to this committee that I will be bringing to you. To begin discussion on this bill, I would like to read to you Article 2, Section 1 of the Tennessee Constitution. The powers of government shall be divided into 3 distinct departments: legislative, executive, and judicial. Article 2, Section 2, Tennessee Constitution. No person or persons belonging to one of these departments shall exercise any of the powers properly belonging to either of the others, except as in cases herein directed or permitted. Currently, ladies and gentlemen, emergency rules are in effect on filing. The Government Operations Committee, this body, which is part of the Joint Government Operations Committee that hears rules as well, can do nothing to stop emergency rules. Negative recommendations have no effect. Therefore, the legislature has their hands tied for emergency rules. As amended, this bill gives Government Operations Committee of either chamber the authority to suspend emergency rules for up to 90 days initially. The suspension may be renewed for another 90 days if both chambers agree to do so. This bill would potentially stop the emergency rule from taking effect with 2 renewals for its entire 180-day lifetime. If the emergency rule is given only a negative recommendation, this bill, as amended, would allow the agency to withdraw the rule. For clarification, let me specify that the amendment as put on there does not keep the emergency rule from going into effect immediately when it is filed. What it does is it gives the Government Operations Committee the power to suspend it for up to 90 days after hearing it. By way of explanation on what that means, agencies come before us with emergency rules usually for one of 2 reasons. One is they're going to lose federal funding if they don't file that rule quickly. And 2 is health, safety, and welfare. Now, there's a third reason, sometimes mentioned, and that is a bill that we as a legislature have passed that directed them to immediately promulgate emergency rules. That said, though, none of those removes the constitutional requirement for the legislature to be the body that is in charge of making laws. And I will remind this body that rules, once in effect, do indeed have the effect of law. Therefore, it is incumbent upon us, representing the rest of our colleagues in the General Assembly, to have some say on this. I would close once again with a reminder. The bill as amended does not prohibit an agency from promulgating emergency rules. However, it retains the constitutional checks and balances on powers that an executive agency is not allowed to promulgate rules with the force of law without some portion of the legislature having a say in it. Now, I could go on and we could talk about the fact that sometimes we have committees or agencies that come before us that have said in the past, we don't care what you say. You can't stop this bill. Therefore, we're not going to do anything about it, and you can't make us. We've had another agency before us that, when directed to make an emergency rule in March, finally got the emergency rule out in November. You know, a child could have been conceived and born in that length of time, and they couldn't get emergency rules out. So that begs the question on timing and the opportunity for this body, which indeed, as I mentioned, is constitutionally charged with making laws. With that explanation, I stand ready to answer questions, Mr. Chair.
Thank you, Chairman Reagan. Committee members, we do have members with the executive branch that would like to speak on this bill. So at this time, we will go out of session and hear from the various departments. If they would come forward, please. And please check the light on your microphone, make sure that it's on, and introduce yourselves for the record, please. And I'm not sure who would want to go first, but on my list, I have Michael Driver, Gary McFarley, Marcia McShane, and Dr. Samantha Beatty. So I guess we could start with Michael Driver first, if that would be appropriate.
Thank you, Mr. Chairman. Michael Driver, Tennessee Department of Commerce and Insurance. I'm actually going to let Assistant Commissioner Farley handle the principal part of the presentation for the Department of Commerce and Insurance, if that pleases you. Thank you.
Thank you very much. Yes, sir.
Thank you, Mr. Chairman and committee members. My name is Gary Farley. I'm the Assistant Commissioner for the State Fire Marshal. The statute sets strict guidelines for when emergency rules could be filed, and my office has relied on emergency rules in several situations to implement legislation or to when required to address immediate life safety concerns. The Volunteer Firefighter Grant Program passed in 2019 to become effective January 1, 2020. My office needed to have rules in place immediately to obtain the authority and award and distribute the funding across the state. Otherwise, we could not have issued 41 grants to the communities across the state, and those are entirely in rural Tennessee. In 2018, after the Parkland school shooting, school leaders across the state requested a change in the adopted codes. As the Assistant Commissioner of Fire Prevention, I am primarily concerned with fire safety, but I do recognize there are other safety concerns that must be addressed too. My office worked with the Department of Safety, Department of Education to provide code-based options to allow both fire safety and school security. We filed an emergency rule in July of 2018 that became effective immediately to allow school leaders time to make the changes necessary before the school year began in August. If this legislation had been effective at that time, schools across the state would not have had the tools necessary to keep students safe from fires and other threats.
Point of order, Mr. Chair. I hate to interrupt, but I don't think he's speaking on the amendment.
Thank you, Mr. Chairman Reagan. Please, sir, continue. Can you just speak specific to what the bill does or does not do, in your opinion?
Well, basically what it will do is it will tie the hands of our office to be able to implement rules. When legislation is passed, when things come up like the school shootings that we needed to change the code, when there's life safety concerns. And what it does, if you suspend the thing for 90 days, then another 90 days, that's 180 days that the emergency rules are in effect anyway. So it actually does away with the emergency rules, and it will tie the hands of our department tremendously if this goes into effect.
Yeah, thank you for that testimony. Any members got any questions for Mr. McFarley? Chairman Lafferty?
Thank you, Mr. Chairman. I thought that I heard Chairman Reagan say that this would not stop the rules from going into effect. It would simply leave the door open for us to review those rules with the option of staying those rules or letting them proceed. Was I unclear on that somehow?
Michael Driver again. I do believe that that is what the most recent amendment does. I do think many of the concerns expressed by Assistant Commissioner Farley remain on rules that could be stayed, or I suppose the potential effect of rules being stayed on the ability of departments to issue and continue to enforce those rules in life safety situations. But you are correct. My understanding of the most recent amendment is that the rules go into effect and then are subsequently stayed.
But the testimony was that these rules would stop that. That testimony, forgive me, seems incorrect.
I believe the testimony was based initially off of the understanding of the previously filed bill. However, I do think that the crux of the testimony is still accurate from the department's point of view on the amendment.
Okay, so just to clear up the confusion then, and I'm taking the chairman's words here, I think, the emergency rule can still go into effect and will go into effect.
That is my understanding.
And it's only if we shut it down that rule would not go into effect. So I just don't want the committee to be confused by the testimony that we just heard, because it certainly confused me. Thank you.
Thank you, Chairman Lafferty. Representative Stewart?
Right. Well, what I heard you say, and I want to make sure I understand, is your concern is that you could have a situation where you issue an emergency rule based on an emergent situation, a health and safety issue, and then this committee, without any further process, could stop that rule for 90 days or 180 days.
Yes.
Is that right? And,
Yes.
And that's never, am I right? That's never been the way our emergency rules have ever worked in the past. Is that fair?
That's correct.
Is the administration against this bill? Seems like it is. Is that correct?
I think we wanted to come here and express the department's concerns on how that would go. Can't provide a specific position here.
Any further questions?
I think you answered my question.
Chairman Todd Warner.
Yes, sir. Could you clarify, is it the administration that's against this bill, or is it the department that's against this bill?
I can only speak from the department as far as I'm not speaking for the administration. I just think it would, the way it's proposed, it would tie our hands to be able to implement something as far as life safety.
And if I may.
Yes, sir.
My understanding is that what we have been hoping to do is find a resolution that would work for the sponsor that would also address some of these concerns raised by
Okay.
the administration and the department.
Chairman Faison, you're next on our list.
Thank you, Mr. Chair and committee. Just so you understand, when a department is here talking against the bill, they are here on behalf of the administration. They don't talk unless the administration against the bill unless they have permission or been instructed to talk against the bill. So they're struggling to answer that. So I just wanted to lay it out for you all. And also, I feel like we've got off in the waters. Let me explain exactly what's going on here. Any department has the ability under the UAPA to promulgate a rule that's an emergency rule. It goes into effect. We eventually meet and and it goes into effect for 180 days emergency with or without us. After GovOps meet, we can say, hey, we don't like that. We don't like that rule. And 180 days later, from whenever we met, from the day that rule was promulgated, the rule goes away. What they're doing here is if a department promulgates a rule, we will meet within a month, because we meet every month, and we have the authority within the month to say, we don't like that and stop the rule. So it keeps it going from 180 days to maybe a couple weeks or 30 days. So I just want to make sure, because I don't feel like that's truly been said so far. And also it puts another thing in there that would allow the department to withdraw a rule. Right now, they don't have the ability to withdraw a rule. There's an amendment on that. So I just want to make sure you understand exactly what we're voting on. I'm not weighing in for it or against the bill. I'm just telling you, this is what it is. And if you see a department up here lobbying against the bill or talking against the bill, that is the administration.
Thank you, Chairman, for that clarity. What's that? And at this time, we'll go ahead and move to Ms. McShane. If you will recognize yourself and tell us who you're with, please.
Hopefully I got the mic on the first
There you
time. I
go.
think that's my first victory with that. And I appreciate some of the comments that have been made. And just to clarify, we are here to share what we believe would be the implications that occurred as a result of the bill if it passed as written with the amendment, for you all to consider when you're determining how to vote on this bill. So I want to make sure that that's what I'm trying to do here today. And I hope that testimony will be helpful. And I'll certainly be happy to try to answer any questions that I don't cover in the statement that I provide. It is correct that there is this amendment which allows suspension of a rule. My understanding is that as written, the departments can pass an emergency rule without notice, and that goes into effect immediately. And this would allow this period of review to occur where it can be suspended for a period of 90 days. And then if the representatives of both the House and Senate GovOps acting jointly determine that an additional suspension of another 90 days wants to take place or should, then that can occur. So if I could, I would like to just provide an example of when these emergency rules have been needed, because they're not needed a lot as far as the Department of Human Services goes, which is where I work. I'm an assistant commissioner over there. But there was an example that our folks provided me that I wanted to share, because I think it's important for you all just to be aware of that when you're considering this bill. There was back in 2014, excuse me, the Federal Child Care and Development Block Grant, and a Reauthorization Act of 2014 is the full name. It's a mouthful. So that passed in order to stay compliant with the federal regulations and laws that applied to our funding for various things, in particular this particular act and the services that we were providing pursuant to it. We had to put in place an emergency rule. So during that time, we simultaneously put in place the steps necessary to go through the formal rulemaking process. Because again, this was a situation that we had to act quickly to ensure that we complied with the new federal requirements, and then also take steps to go through the full rulemaking process to make sure that our regular rules were consistent with the emergency rule and also with the federal law. So just to kind of recap, the rules needed to be drafted to provide 12 months of eligibility for transitional child care for these parents, even if they had a temporary change in their work, training, or education status. That was the difference. Previously, if that change occurred in that 12-month period, then they would not be entitled to that ongoing child care. So we had to ensure that we complied within the deadline to make that occur. And again, since this was something that was a directive, if you will, from the federal government, if we failed to comply with that within the deadline we were given, we'd have a penalty. At that time, it would have amounted to 5%, and that would have been a loss in federal funding of about $6 million. So again, not saying this is good, bad, or ugly, just saying that these are the types of situations where emergency rooms might be, or emergency rules rather, might be necessary. And that's how we have handled it in this recent example. And I'm happy to, again, try to answer questions as best I can.
Yep, thank you for that testimony. Chairman Cochran, please.
Thank you, Mr. Chairman. And so one question I had, the emergency rule that you're referencing in your example, was it ultimately approved by GovOps?
Yes.
Okay. So it wasn't denied. So
I don't believe so.
okay. So I guess my question would be, with the amended version of Chairman Reagan's bill, in the scenario you presented, nothing would have changed other than you would have come to us earlier rather than after 180 days, correct? Like we would have had the opportunity to take action earlier than 180 days. No action was taken. No negative action was taken. And so I guess that's my ultimate question. What's the difference? Other than having to come before us earlier where we could actually take action, what's the difference in 30 days and 180 days if in your scenario it was approved anyway?
Sure. I think the difference would be that under the amendment, as I understand it, and please correct me if I'm wrong about this, I believe that we were allowed to put into place that emergency rule immediately, and it was effective immediately without notice, while at the same time moving down the regular path to get the regular rule, if you will, the non-emergency one. So depending on what the deadline was, that could be an issue. Again, I don't have the timeline down for that particular situation and when the subsequent meetings took place to answer that definitively.
Okay. Thank you. And we'll let Chairman Reagan clarify. It's my understanding, though, with the new amendment, the rule would go into effect immediately. And then just at that next regular meeting of GovOps, at that point, you have to come and say why that rule is needed and defend the rule. But we'll let the sponsor clarify that. But it's my understanding nothing has changed. The rule still goes into effect immediately. And again, we'll let him explain when we go back into session.
Chairman Reagan, clarification on what was just said.
Thank you, Mr. Chair. Since we're out of session, that which was explained by my colleague is correct. The rule still goes into effect just as it has before. The difference being that instead of the rule being in effect without any legislative oversight, it must come before government operations for our review and approval.
Thank you,
And that's
Chairman Reagan.
after it's in effect.
Very good. Next, we'll move to Dr. Beatty, please.
Good afternoon. Excuse me. I'm Dr. Samantha Beatty with the Tennessee Department of Agriculture. And my initial comments were based on the rule as written without the amendment. But I will say, to add to the comments here today, that with the stay of, in my mind, a particular emergency, which is what I wanted to share with you today, how it could negatively impact livestock producers in the state. And so we prepare every day. Our job is to make sure that animals and animal industry are protected. And one of the things we do is emergency preparedness. Excuse me. And much like in people, animals get diseases. Animal commerce happens 24/7. There are animals on the road right now. Tennessee receives animals from 36 states at one plant every single day in Canada, and also 17 states at another plant on the east. And so the reason that I bring this up is because we have reportable and foreign animal diseases that are sitting at our borders. If you were aware, we're in the middle of a response to high-path avian influenza. But our partnership with USDA is very important, and they rely on us to enforce some rules. I've only utilized the emergency rule one time since I've been in this position, but these are all available on the web. But basically, there are response plans, and I work regionally with other state veterinarians to decide how we're going to respond with federal guidance. And one of the things that they'll rely on us to do is if we have a detection of foot and mouth disease or African swine fever on our soil, we will need to stop the movement of all animals. There'll be a 72-hour standstill at least.
Question for you, Dr. Beatty. The bill as amended, will it help or hurt your situation in any of those?
The bill as
situations?
amended would leave our situation the same unless there was a reason to stay the amendment.
Okay, thank you. Committee members, any questions for Dr. Beatty or any of the witnesses? Seeing none. Thank you for your testimony today. And members, at this time, we'll go back into session. Chairman Faison.
Thank you, Mr. Chair. I do have a question for legal, and I feel bad. I should ask you while we're out of session. And this is my question. Understanding the UAPA legal as how it's the federal recognition and how it's been upheld in court, is there any constitutionality issues with this bill as amended that you, in your legal perception, would see?
Legal. We will go out of session.
Katie Robertson, Office of Legal Services. The Tennessee Attorney General has opined that once the General Assembly grants administrative agency rulemaking authority, the General Assembly may only interfere with the rulemaking process through the enactment of subsequent laws, and that a legislative veto may not be delegated to a single House or committee of the General Assembly without contravening the doctrine of separation of powers.
Chairman Reagan or Chairman Faison, please.
Thank you. And that was an opinion of an attorney general, and it was not settled in court, or was this upheld in court, or was this a lawsuit? Can you help us with that? And what year was that?
The Attorney General opinion was March 11th, 1982. He based his opinion on other state case laws and their UAPA and how it was settled in court in those other states, but there has not been a specific lawsuit in Tennessee on this.
Chairman Faison, did that clarify?
That was it. Thank you.
Chairman Cochran.
Thank you, Mr. Chairman. And mine is a follow-up for legal also while we're out of session. Just want to, so the Attorney General's opinion that you just read, applying the current amended bill to that, I'm trying to think how to properly ask this question. You mentioned that constitutionally, in that opinion, you could not have a veto power of just one body. Would we say that the way that the bill is currently written, that it is written that only one body is vetoing currently? So my quick question is this. Currently, it says either the Senate or the House Government Operations Committee could stay the rule. According to that Attorney General's opinion, would that be saying that it would need to be the Joint Government Operations Committee, where it would involve both houses? I hope I didn't muddy that too much. For the amendment, that's correct.
So it's unclear what in the Tennessee Attorney General opinion on what veto means, but it could be interpreted that the Government Operations Committee, either House or acting jointly, would be delegated authority of suspending a rule.
Chairman Faison.
Thank you, Mr. Chair. And legal, from my understanding, when the House or the Senate stay a rule, such as what they would potentially do here, it's not just the committee that does that. Eventually, it makes it to the House floor and the Senate floor. So the entire legislative branch of government is the one who agrees with what the subcommittee or this committee did. Am I thinking correct on that?
So that is correct on permanent rules where we bring the rule omnibus bill and then it's voted on the General Assembly as a whole. But the General Assembly as a whole does not act on stays.
Chairman.
Emergency rules become permanent rules. Yes or no?
No.
Sometimes they do, but that would need a
Depends.
subsequent.
Yeah.
file it.
According to the Attorney General opinion you just read, when we stay a rule after 180 days, what's the difference in us doing it within 30 days or 180 days as compared to what that Attorney General opinion was? So it sounded like to me that Attorney General's opinion from 1982 said that we constitutionally don't have the right to veto. That's the word he used. Or I guess right now we're going to say stay a rule. So we can do that already. Our laws are allow us to do that at 180 days. I'm wondering, what's the difference in doing it 180 days or within a 30-day period? I'm not seeing any difference as what it has to do with what you just read.
The Tennessee Attorney General opinion does not specify, and it
Right.
doesn't go into staying of a rule.
Right. Okay. Thank you. That's it from you, Mr. Chair.
Any further questions or comments for Ms. Katie? Seeing none, we're back in session. Any further discussion to Chairman Reagan? Chairman Reagan, you're recognized.
Thank you, Mr. Chairman. And since I authored this bill, I'll clarify the legislative intent behind it I hope, clearly. I specifically chose the term suspend so as to completely get around veto. A suspension is just that. This body can act to remove the suspension just like we can remove a stay. That's not a veto. Therefore, the Attorney General's opinion from that standpoint is inoperative. Secondly, the idea that an agency, an executive agency, is empowered to make laws without the legislative body being able to exercise any kind of oversight on that, to me, is against our Constitution. Let me point out, too, that Title IV, Chapter 5, 208, which is entitled Emergency Rules, specifies in subparagraph D, any action contesting a rule adopted in reliance on this section, in any action contesting a rule adopted in reliance on this section, the burden of persuasion shall be on the agency to demonstrate that the rule meets the criteria established by this section. Subparagraph E, an agency's finding of an emergency pursuant to this section shall not be based on the agency's failure to timely process or file rules through normal rulemaking processes. Very clearly, what that says to me is the agency is encumbered with the very important duty of persuading anybody who says their rules shouldn't be in effect. And that includes us, most especially us as members of the General Assembly. The idea that they can come before us, as one agency did quite famously last year, and say, we don't care, the rule's in effect, we ain't changing it, we ain't withdrawing, you can't do a thing about it. That, to me, is an indication that this body needs to have the ability to say, no, rules have the force of law. We are the branch of government identified in Article 2, Sections 1, that is in charge of the law. To me, this is a separation of powers issue in its entirety, and the legislative power belongs in our body.
Representative Stewart?
A technical question, but am I right? The way your bill works as amended is, Mr. Chairman, if it suspends it, whatever emergency rule we're acting on essentially is stopped. Is that right? I mean,
Its operation is suspended. That is correct, sir.
lawyers can argue over whether that's a veto or not, but it has the effect of taking the words that the department has created and giving them no effect during the suspension. Is that how that works?
Chairman Reagan?
That's how it worked, but I will point out to you, a suspension, unlike a veto, is not permanent.
That was my next question. Go ahead. I had to follow
Well,
on.
the suspension, it says the bill says up to 90 days. As a body, we could choose any point in between 0 and 90 and say we're suspending this rule for 10 days until such time as we are satisfied, as I pointed out. The burden of persuasion belongs to the agency, not us. It's upon the agency promulgating those rules to persuade us. If in the interim we are persuaded by evidence that they present, we can remove the suspension.
Representative Stewart?
And I guess you and I, the reason I'm less worried about this, I mean, at the end of the day, to me, we had a big gubernatorial election, elected Governor Lee. As you know, he and I probably have a few issues we disagree on, but he was elected. And to me, these agencies effectively, the public's control over the agencies comes through our statutes and comes through the governor's directive. So there's a lot of public control. But could you help me under the new amended bill? Okay, there's an emergency rule, we suspend. When does the Tennessee General Assembly get in the game writ large to address this? What happens after we suspend?
Chairman
Bill,
Reagan.
can you walk us forward?
There is no change going forward with what we have always been able to do. Without going through the entire Title 4, Chapter 5, which would be a burden I'm sure nobody wants to go through. Let's just say that this does not change anything going forward. The only condition it puts on there is it reinforces that portion I just read you. We, as a body, can say, the emergency rule you've brought to us and the explanation you've given us for it has not persuaded us. And the burden is on the agency to do that. Therefore, we, acting as a body, say the rules operation is suspended. At any time after that, that they persuade us that it is in fact something that we should remove the suspension on, we have that power.
Follow up, Representative?
Just one more follow-up. I mean, the reason I'm asking is, seems to me, like you say, 4-5 has not changed. Isn't 4-5 designed, the reason you have these 180-day, these lengthy periods, is it's designed essentially to allow the executive branch to take charge of these emergency situations. And then really this body, this committee can weigh in, but effectively the law is designed such that if the legislature wants to act as a check, it has to do it sitting as a whole. Essentially, this committee has the ability to advise, has the ability to take positions, but because of the timing structure, really the real check on the administrative agency is the legislature. It seems like the big change in your bill is that now this committee, this group, really will have the right to stop an agency from doing something. And to me, my concern about that is, this is a select group. It's a good bunch of people, but we're not the state as a whole. To me, I don't think it's a good idea for us to essentially substitute our judgment effectively for our state's executive, who, of course, unlike us, was elected by the people as a whole and has been essentially entrusted with these executive actions. I think the people of Tennessee, when they think about forest fires, immediate safety issues, the kind of things you get executive orders or emergency rules on, I think most people think that they've given that power to Governor Lee, not to us. And
Chairman
to me,
Reagan,
anyway, to me, the way the rule works right now, the balance is it's all structured to force the General Assembly as a whole to take issue, not this group right here. Is that a fair reading?
Chairman Reagan.
It's partially correct, sir. The General Assembly, as you are well aware, only meets from January until sometimes in May. This committee meets monthly as a representation of that body and exercises oversight on behalf of that body. Therefore, I submit to you that the argument you put forward might be valid at such time as we are in right now, where we're in session, but would not be otherwise. I'll also point out to you that reliance on a subset of individuals that work for the governor is not the same as, who was elected, by the way, is not the same as reliance on all of us who are directly elected.
Thank you. Next on my list is Chairman Warner.
Question on the bill.
A question has been called. Any objection? Seeing none. All in favor of moving House Bill 1748 to calendar and rules signify by saying aye.
Aye.
Any opposition? Nay. No. Bill passes out to calendar and rules.
Thank you, committee members and Mr. Chair.
And at this time, anyone have any comments, personal orders? Seeing none, we stand adjourned.